All right, welcome everyone, and thank you so much for joining us today for the webinar titled, Are Your Board's Emergency Powers Still in Effect? Before we get started, we just wanted to run through a few things to keep in mind during the webinar today. First of all, we appreciate all of the many questions that we received in advance. Those were taken into consideration when preparing the content for the presentation. Once the webinar begins, you will notice a Q&A button at the bottom of the Zoom window. If you have a question that you would like to pass along to the panelists during the presentation, simply click this button to open the Q&A pop-up window, and you will be able to enter your question there. And all questions that aren't addressed during the live webinar are reserved to help future content. So we definitely encourage you to use this feature. Additionally, a link to the full webinar replay will be emailed to all registrants and attendees 1 to 2 days following the event, so you will be able to watch or share the webinar afterwards. With that, I am going to now turn it over to your moderator, the chair of Becker's Community Association Practice Group, Ken Direktor.
Thank you, Laura. Good afternoon, everyone, and thank you so much for joining us. This is the second webinar for this particular team. My name is Ken Direktor. As Laura said, I am the chair of the Community Association Practice Group at the Becker and Polikoff Law Firm. I work out of the Fort Lauderdale office. I am joined by my partners, David Muller from our Naples office, Jay Roberts from our Fort Walton Beach office, Rosa de la Camara from our Miami office, Coral Gables to be precise, and Donna DiMaggio Berger from our Fort Lauderdale office. For those of you who joined us last time, we're going to follow a similar format where we're going to have what I hope will be a flowing discussion. The phase we're at now, as opposed to last time, the phase we are at now is more oriented toward reopening, how to reopen, do we have to reopen, under what conditions can we reopen. So let's start though with where we are legally, and then we'll get into where we're going. And David, I want to turn first to you. When we did our last webinar, you discussed the emergency powers that were being exercised by the board to navigate the crisis, whether it be closing certain amenities or restricting access to the property. Are those emergency powers still in effect?
Yes. Again, the emergency powers contained within the respective community association statutes, they are still in effect. Those emergency powers, those statutory emergency powers, are triggered when a state of emergency is declared. On March 9th, Governor DeSantis issued a state of emergency for the entire state. It lasted for 60 days, and via subsequent order on May 8th, he extended the state of emergency. So it currently is running through July 7th, and it is subject to potentially further extension. We're going to see what happens, but as we speak today, we are under a state of emergency, which, pursuant to the statutes, has triggered the emergency powers for community association boards.
So notwithstanding the continuation of the emergency powers, David, we're all seeing government orders allowing the reopening of certain facilities and certain businesses. What impact do those government orders have on the board's authority to continue to restrict access to the community and to continue to close off amenities from access?
Right. It's a good question. It's important to remember that none of the applicable executive orders issued by Governor DeSantis, including his phase 1 and his phase 2 orders, specifically require community associations to take an action. All right.
Is it fair to say that they permit rather than mandate these reopenings?
Correct. And that's been part of the misconception here, is that by the phase 1 and the phase 2 order, clearly those orders impacted things like theaters and other types of businesses. There's been a misconception that community associations were brought in underneath those particular orders. Now, it's important to remember some counties have adopted certain orders which do require community associations to act. In Southwest Florida, where I practice, none of the counties in my area have adopted these types of orders, but I know particularly in Southeast Florida, that's not the case. Rosa, what have you seen as far as county orders in your practice area in Southeast Florida?
Well, I mean, in Southeast Florida, we've seen a lot of municipal intervention, if you will, but it's been necessary sheerly by the amount of cases we've seen in this area. So there are mandatory guidelines, and I know Ken wants to delve into that in a minute, mandatory guidelines by certain municipalities that are stricter than what the state or even the county government has mandated. So it's imperative that each association check not only with the state and the county, but also within the individual municipality.
David, I want to bounce back to you because there were a lot of questions about the order that came out initially from the DBPR and then the subsequent one that recently came out. And people are out there assuming that those orders have some impact on the board's continuing authority to exercise emergency powers. What are your thoughts on that?
Right. The two orders you're referring to, the first was issued on March 27th by Secretary Beshears of the Department of Business and Professional Regulations. And it specifically stated that the statutory emergency powers contained in the applicable statutes for community associations, that they were available for use by community association boards to address the threat posed by COVID-19. Now, at the time that was issued on March 27th, most lawyers who practice in this area, their immediate thought was, well, okay, but does the DBPR really have the authority to determine what a statute does and doesn't do? Things got a little bit more complicated when on May 20th, Secretary Beshears entered another order. And this time the order said that effective June 1, those emergency powers shall cease to exist or shall cease to be available. Now, again, both orders are curious and candidly, they're legally suspect. You know, the DBPR is not empowered to render general pronouncements of law or interpret or expand the scope of existing law. And as a result, you know, these orders, from my perspective and most practitioners' perspectives, you know, they don't change the reality that the statutes that I just referred to earlier in this webinar say what they say, and we're under a state of emergency. So very curious and legally suspect, those orders.
Thank you, David. Donna, one of the other things that we're hearing regularly is, well, our neighbors are reopening, so why can't we?
Yeah.
What is the response to that?
Well, comparison can be the root of much evil, and that's particularly true in this situation. We've had boards under pressure for many weeks and months now in terms of when are we going to reopen, particularly with regard to the pool. And this is particularly true when you're talking about large associations with a number of sub-associations, and people are looking to see what their neighbors are doing. But I would urge the boards, each board needs to address their unique circumstances. This is not, reopening is not a one-size-fits-all situation. Your community needs to take into account your own factors. Number one, does your budget allow you to properly hire staff to properly monitor and clean so you can be operating in accordance with any applicable local order? Number two, what does your resident population look like? Do you have a particularly vulnerable population? This is true in many of our 55 and over communities, but even in other communities, you may have a significant percentage of residents who are elderly, have underlying health conditions, or otherwise vulnerable. What does your budget look like? Do you have an active infection? Obviously, if you have an active infection or an active quarantining situation, that has to be a factor as well. So just, your answer, if something goes wrong and you're asked why you felt the need to reopen, it can't be, your answer cannot be everyone was doing it.
Rosa, speaking of active cases, as Donna just did, what does the number of new cases currently occurring in your region do to impact the board's evaluation of how to continue to manage the crisis and how to continue to restrict access to or the use of certain portions of the property.
Well, that's really what we grapple with every day, Ken, in my neck of the woods. In Miami-Dade County, you know, one thing that I will notice in observation since this team last presented together in the last 3 weeks or so, we've really seen a development throughout the state, and it lets us kind of get our arms around it better. Donna and I see, I think, a lot more cases than maybe what David and Jay see in their neck of the woods. So I think we have to counsel our clients a little differently than what they do. It's not a one size fits all. So in Miami-Dade County, where I practice, there's a mushrooming effect with these cases. They really haven't subsided. We've got the largest amount of cases in the state. As of this morning, I think we had 20,000 cases in our county. From a 65,000 total number of cases in the state. That's a whopping amount. And in Miami-Dade, we've probably got 240 average new cases a day. So the reason I say these stats is because it's very important to understand your community and your demographic. And by mere and sheer virtue of the number of cases here, I think boards have to be cautious, and I think boards have to be careful, really irrespective of what the demographic is, but even more so in some of those communities, as Donna said, in the over 55 or in the ones with the elderly population.
Jay, the other thing that we're seeing a lot of is snowbirds who haven't been acting like snowbirds. It's June and a lot of them are still here. And you know, I say that with a smile on my face, and the managers think that with a smile on their faces. But by the same token, it means we have a higher population right now than we normally have. They may be people who haven't traveled because of their age or health conditions. How do those factor into the board's decision on how to continue to navigate the crisis?
Yeah, Ken, I think that my response is kind of an amalgamation of Rosa and Donna here. I mean, you need to start thinking in terms of all risk factors when you're determining what actions you're going to take on the board. Some of those are geographic. You know, Rosa mentioned what Miami-Dade looks like. You could put the 6 counties that I cover up here together, and it does not get close to the numbers that Miami-Dade's facing. Does that mean that you don't be careful? Of course that doesn't mean that. But you need to realize, what are the fact-based situations in your area? What are the fact-based situations in your community? Do you have a lot of people in residence? Who are those people in residence? Do they have additional health risk factors that you need to be considering? I think Donna was exactly right by pointing out that you need to figure out your budget. CDC has come out with guidelines, people. There are guidelines on community pools on the CDC's website. Should you be following those? Yes, you should be following the CDC's guidelines. But what pressure does that put on your budget? I mean, these are things that are real world situations that you need to be considering when you are determining what actions you're going to take as the board.
This is a very important part, and a lot of the questions that I saw from our audience pertain to what to do at this juncture. You've just heard a lot of good ideas, but also a lot of good suggestions for the factors you need to consider. But I want to start with one of the misconceptions that David dispelled. Just because the government orders are loosening doesn't mean that you automatically are required to do so in your community.
Ken, if I may just jump in for a second, because Jay just made a really important point about budget. Many associations are thinking about the budget in terms of having staff to monitor and clean, but another component is having a budget that's going to allow you to enforce these protocols once you reopen. It's not good enough to just create the protocols, to have the staff that are monitoring and cleaning, but when you notice that people are violating those protocols, you have to have the budget to be able to proceed with enforcement.
Donna, hearkening back to Jay's comment about governments, you've been appointed to head up a task force for the Florida Bar to revisit emergency powers provisions in the statute. What is the future of emergency powers going to look like, and how's it going to differ from what we used or what we employed to protect our residents and our staff during this pandemic?
Well, we have a great task force that's been compiled by the Florida Bar's Real Property Probate and Trust Law section. And our task has been to look at the emergency powers that were added to Chapter 718, 719, and 720 years ago in response to hurricanes. Back then, the feeling was, rightfully so, that our volunteer boards needed some real guidance and tools to be able to contend with the aftermath of a natural disaster. Now, as David pointed out at the outset, many boards have relied on those existing emergency powers to contend with this pandemic, specifically relied upon provisions in those emergency powers to shut off access to the property to outside visitors, and that could have included contractors, realtors, out-of-state guests, basically non-essential visitors. Boards also use portions of those emergency powers to hold meetings electronically. They use portions of that to close down the recreational amenities. But I will tell you, and I'm sure everybody on our panel would agree, there was some hesitation and some confusion about what applied and what didn't apply. And as David said at the outset, the DBPR came out and said that certain of those emergency powers applied, but others didn't. What this pandemic has revealed is some of the gaps in those emergency powers. So the task force has been assembled to really clarify that as to when, we already know when they come into existence, when the governor declares a state of emergency, but when does it end? And exactly how much can these boards do to contend with an anticipated event? Because the way the statutes are worded right now, it really is a better fit for damage that occurs in the aftermath of a natural disaster. So if you're asking me what the future looks like, if my task force does its job, and we have some excellent attorneys around the state who are dedicating a lot of time to fleshing this out, what we're going to be able to do is we're going to be able to provide that guidance and clarification so we don't have to look solely to these orders that are coming out, many of which create more questions than answers.
Panelists, at this juncture, and I apologize if you can hear noise coming through my microphone, people, but my neighbor apparently has a weed whacker that is powered by a jet engine. The boards seem to be caught right now between the owners who have conflicting demands. You have those who insist that they have the right to do renovations, to have vendors, to have real estate brokers, to have guests, to basically use their units as they normally would, because if the businesses are opening up, why can't we? And then we have those who want the building to remain in some state of shutdown because they fear for their safety. Donna, your last thoughts last time when we concluded our last webinar were that safety has to come first. So what are you telling your board members in terms of how to balance these clearly conflicting interests and still make safety a priority?
I think we all agree, Ken, that convenience has to take a back seat to safety. Okay, I haven't heard any clients argue that it should be the reverse. However, I think board members have to, when they're approaching these decisions, look first to what is for the good, what is in the best interest of the community overall. You know, board members have personal interests. Board members, you know, you may have people sitting on the boards that are the first people that want to use the pool. You may have board members who are realtors and they wanted to rent out units. You may have board members who are landlords and rent out units. You have to, as a board member, approach these decisions and put your personal interest aside and look to what serves the best overall interest of the community. So that's one of the trouble spots that I've identified when having conversations over the last few weeks, is that sometimes it's not the residents alone who are pushing to reopen this thing. Sometimes it's members of the board that are also looking to reopen. And this is where it is going to be so important for board members to all get involved. All of us on this panel have seen over the years that sometimes some board members are sitting on that board and they're not truly engaged. They're a little detached from the overall conversations, and they let one or two board members really drive the bus. When you're operating in the midst of a pandemic, when you're talking about opening amenities and providing services again in the midst of an ongoing pandemic, we heard Rosa, she's got numbers that are going up. In Broward County, we've got numbers that are still going up. This is a conversation that requires everyone on the board to be engaged. No one can afford to be detached at this point. And frankly, if you make a misstep, it's going to affect everyone equally, whether or not you agreed with it or not.
And Donna, I think it bears repeating the point that you've been making since you started to speak on this subject in early March, which is do not think that one size fits all. What your neighboring building may be allowing contractors, but your building may have a positive case or 2 or 3. And you need to take a holistic view of what's going on in your building to make an informed and defensible decision on how to continue to navigate this crisis.
Well, some people are more comfortable gambling too. Some people are luckier. I mean, we have this conversation when it comes to why can't I charge $500 for an application for a screening fee? My neighboring building is doing that. We know you can't do that legally, but some people have a different way to evaluate risk.
Karen, can I just jump in a minute too, just to piggyback on something Donna said? I think it entirely is a valid conversation that the board needs to have. They really can't feel, manhandled by the owners. They can't feel pressured. It's tough. It is a very tough discussion because you want to do right by the owners. But what I was going to say is if you are going to reopen, especially in, the areas where Donna and I represent clients, Southeast Florida, you really ought to look at the guidelines that are out there. And the Florida Department of Health and the CDC has excellent guidelines out. So it's not just a free-for-all, let's reopen, the carnival's here. If you go to the cdc.gov website or the floridahealth.gov website, they've got some excellent safety guidelines that really need to be followed by everyone. I don't care what part of the state you're in, but especially where we have the high recurrence of the cases.
And Rosa, to that point really quickly, our task force is going to be looking to incorporate those kind of medical professionals into the emergency powers as sources that boards can look to when creating protocols.
David, what about insurance? How does the availability of coverage factor into the board's approach to, as Donna said, gambling or weighing the risks?
Right, insurance is always an important consideration, and I'm not just saying that because I used to be an insurance defense attorney. I'm saying that because it's a very real consideration. So as we've talked about in this webinar, boards are being forced to walk the line. You could potentially get sued in 2 different ways. You could get sued by an owner or resident who states that because you failed to take proper steps, they contracted COVID-19 and suffered health effects and possibly even death. You potentially could be sued by that side of the line. On the other side of the line, you have the owners who are furious that they were not able to go forward with their unit renovations that were slated to begin on May 1st as soon as the construction moratorium ended. So they might sue you as well. So whenever you're concerned about potentially being sued, it's always a good idea to call your insurance agent and have a discussion about what's covered under your policy. Now, many of my clients have called their insurance agent to talk about these potential different ways they could be sued as it relates to COVID-19. And from the feedback I'm getting and from the feedback I've learned from other insurance agents, there is an environmental contagion exclusion contained in many policies. So the reality is if somebody sues the association for COVID-19 transmission because the community, the association failed to take proper steps, if you have that exclusion in your policy, it's a possibility there's no coverage. And if your agent confirms that for you as a board, that should be a very big part of your analysis as far as what you want to do, because no one wants to get sued when there's no insurance coverage. And then of course, compare that to the other type of lawsuit, the lawsuit where you are prohibiting renovations from going forward for a period of time due to the COVID-19 threat. That under most insurance policies, that's probably more likely to have coverage because it's a different analysis than the environmental contagion exclusion. But as with all things insurance related, your insurance agent is the keeper of all your policies. They live, eat, and breathe that's the insurance developments and changes. So you always want to keep in touch with them and get their perspective.
It is a challenging time to be a board member, wouldn't you say, panelists? Rosa, what amenities are being opened at the condominiums that you're working with? And can you give our listeners some idea as to the kinds of conditions that are being imposed as amenities are reopened?
Yeah, sure. Well, you know, we're sort of lucky in Miami-Dade County that we have the mayor's 186-page guidebook, which contains both mandatory and recommended reopening protocol. And for example, pools have been able to be reopened now for about 10 days or so, and most associations in my area have reopened their pools. But again, it is not just a free-for-all, let's reopen the pools. There are some requirements that have to be followed. You have to have an ingress, you have to have a specific egress, there has to be specific signage posted. There need to be hand sanitization stations, and there have to be a whole myriad of things done in that regard. Gyms also, as of yesterday, the gym rat that I am knows this, as of yesterday, gyms were able to be reopened again in my county. So everyone was very happy about that. I do think we have the dubious honor of being the last county in the whole nation to reopen the beaches. They were supposed to be open June 1st. Because of certain, you know, protests and what have you, our mayor decided to hold off, and they're going to be open tomorrow, thank God, finally. So it's been a slow process, but I would say that as long as my clients in Miami-Dade County are in compliance with the new normal guidelines proposed or required by the county, and to some extent the stricter guidelines required by certain municipalities, then they'll be fine. They just have to follow that protocol.
Rosa, let me ask you to segue over to access to the building. Housekeepers, dog walkers, contractors, guests and visitors. Are you seeing associations allow this? And if so, on what conditions?
Well, I've seen a loosening up of that, because at one point we said, I mean, my client said, no, absolutely no one comes into the building unless it's a resident that is authorized to be residing here. No guests, no visitors, no contractors, no outside persons, no food deliveries, no Uber Eats. I mean, no one was allowed to come in. That's been loosening for obvious reasons, because we're getting back to the new normal. But I will tell you that not only the CDC, the Florida Department of Health, and certainly my county still requires what everyone else is requiring, what the whole nation is still under, which is social distancing is required, facial coverings are required. You can't just walk around and waltz around without the facial covering. Everybody still has to wear a mask, and you still have to keep socially distant. And you still have to have the hand stations throughout, you know, spread around the common areas that you are reopening. So it's not just a free-for-all. Also, the final point I want to make in relation to that is you can establish limitations on the number of outsiders that come in at any given time. So people have been kind of cooling their heels for the last 3 months and not getting work done, and the maids haven't been coming in, but it shouldn't be a free-for-all. It should be maybe a registration process. Let me know who you're having come in and when, and kind of control it that way, as opposed to opening the floodgates and have everybody swarm in at the same time.
And Donna, coming to you for a second, Rosa spoke of the importance of some of the government orders. In the areas where you represent clients, particularly in South Florida, have there not been some government orders that have specifically said you can, for example, open the pool, but for residents only?
Yeah, that's contained in the Broward County order. And what I'm basically telling clients is, again, those orders represent the floor or the minimum of what a board can be considering when compiling their own COVID-19 protocols for reopening. So the Broward County order says resident usage only, and it actually said current resident usage only. The Palm Beach order did not say that. The Palm Beach order said you have to close your showers. The Broward order didn't say that. So if you're in Broward, you may say, you know what, we want to close showers too, because that's a source where we don't want to keep cleaning that. The Broward County order provided an option to say remove all your furniture. Just because the Palm Beach County order or the Miami-Dade order might not have addressed that doesn't mean that your board, wherever it's situated, again, depending on your unique situation and circumstances can't pick and choose from the various orders and say, you know what, that makes sense for us.
Jay, when we were last together to do a webinar, you discussed the application of the business judgment rule. How has the application of that rule changed with the evolution of this crisis now toward a reopening? There are so many specific instances that we've touched on. I'd like you to tell us how the business judgment rule is applied, whether to housekeepers, to personal trainers, to social guests, to contractors, and furthermore, do we still have a quarantine obligation in place for people coming from certain hotspots?
Yeah, well, you guys do. We don't have much here because most people from the tri-state area don't visit us here. They come straight to you, Ken, and we applaud that. But what we have here, everybody knows that I'm right. So what we have here is I like to think about, we basically, from leaders of communities, you've moved from one kind of knife to another. We started off with a machete. The machete was, we don't know what's going to happen. We need to close down everything. Everybody else is closing down everything. We're closing it down. Great. You wielded the machete. You had the courage to do that. Now the reopening is a scalpel. The scalpel. You don't reopen with a machete. You reopen with a scalpel. That means that you have to take into considerations, if we're going to allow contractors, we need to figure out, as Rosa said, the registration process. How are we going to keep the numbers down? If we are allowing the pool to be open, we have to make sure that we have a plan in place to follow any local guidelines, CDC guidelines, DOH guidelines. Those have to be followed. So my point of this is, you have to use the scalpel for each individual thing. It's not just slam the door wide open. It is, we need to figure out the specific things. And coming back to your original point, look, the business judgment rule, as you probably recall, everybody on here, is a concept in the law to where judges will not play Monday morning quarterbacks on directors trying to make these decisions, so long as those decisions are reasonable and they are made on a rational and logical basis. So what's my advice? My advice is that you take your scalpel and you start thinking through each one of these different areas, whether it is gym reopening, pool reopening, housekeeper reopening, contractor and construction work reopening. You need to have different buckets for each of these, and you need to act accordingly with these, and not one size, as Ken said several times, fits all. You may have the pool open because you can do your proper social distancing. You have the abilities to do the cleanings and the disinfecting, but you may not be able to deal with contractors at this point. You just don't have the resources to do it. So you need to take a hard look as community leaders of what you can do and what you can't do from a practical standpoint.
Let's get into some other specifics then. Donna, for example, we're hearing a lot about hold harmless agreements and releases being required before people can use the amenities that are being reopened. Can a board condition an owner's use of the common elements on an owner's execution of such an agreement?
Well, I think it's problematic for a number of reasons. First, the courts generally disfavor these kinds of releases. I think the use of waivers, releases, hold harmless agreements often provide a false sense of security to the board that this somehow insulates them. And again, I'm going to turn back to what David said. It's so very important that you have that conversation with your insurance agent to see if there's any sort of claim. There will be lawsuits. Hopefully there won't be that many, but there will be lawsuits across the board. And I often think there's a disconnect with residents who maybe don't understand that if the association is hit with a lawsuit, it's going to impact them too if there's no insurance coverage. That means the board's going to have to levy a special assessment or tap into reserves if they have reserves to, at the very least, provide for a legal defense. Even if it's a completely frivolous claim, you still have to respond to frivolous claims and get yourself dismissed. So in terms of signage, you know, I know a lot of clients are saying, well, we post a sign, use the pool at your own risk. Or we're requiring people who want to use the pool to sign a release or a waiver. Here's the issue. You're dealing with a communicable disease. It's very difficult because this is a different kind of liability than somebody who can't swim, reads the sign, jumps in the pool, and drowns. That's number one. The people who may ultimately be the ones with potential claims may not be the people who read the sign or even used the pool. They may be people living in a household of somebody who did use the pool. Number two, with regard to waivers and releases, here's the situation. If your pool is open, it's open, particularly in a condo or a cooperative where the right to use the common areas is an appurtenance to your ownership of a unit in that community. What are you going to do if your condo owner says, no, I'm not signing your waiver or your release? In that instance, you are arguably taking away an appurtenant right of that owner because you're conditioning use of the common elements on that person signing a waiver or release. And I think that's going to be subject to legal challenge. So at the end of the day, that's yet another factor to go into deciding whether or not to open. If the pool is closed, you don't have those challenges.
Donna, I want to ask you a quick follow-up, and then Jay, I want to circle back to you with the questions that are coming in response to your last
And
comment.
Ken, I also want to address the release issue, but I'll let you ask your question and then I want to jump in on that.
Well, the issue is, and Donna, I want to know if you think it's fair to say that the concept of releases or hold harmless agreements or putting a sign up saying assumption that you use these at your own risk, is it fair to say that that's kind of the board punting their responsibility? Isn't it more accurate to say that if you're going to open the amenities, you have to open them and operate them safely and in compliance with the conditions in the applicable government orders?
Conditioning use of these amenities on owners signing a release or a waiver does not in any way insulate the board from a claim that they were operating these amenities in the midst of a statewide state of emergency and providing a substandard duty of care. We have to get back. The overarching question here is, are you as a board providing a standard of due care right now in this moment in time when we have an ongoing pandemic and we are subject to a state of emergency until July 7th? You waiving a release does not in any way address whether or not your board was providing the standard of due care. It might make you feel good. It might be another tool in your toolkit, but it is not going to completely insulate you.
And was it not, it's my recollection that at least one of the orders from either the city of Fort Lauderdale or from Broward County specifically said, if you can't open the pool and operate it in compliance with our criteria, don't open it.
Correct, that's the point. You can't use a release, but then not have a monitor or the heightened sanitization. These two things are not compatible. And also, as I said at the outset, courts really disfavor the use of these kinds of releases.
Rosa, before you make your comment on releases, just a quick circle back. Jay, I want to come back to you. So there are questions coming in, not surprisingly, with regard to the what if. If we allow a housekeeper, or more importantly, if we allow a contractor to come in and do renovations in a unit, and we adopt a set of conditions, as Rosa alluded to earlier, and the contractor violates the rules, what do we do about it?
Yeah. Well, look, your legal remedies are still in effect. I mean, the courts, although operating differently these days, are open. And, this is one of those instances where, as a person that used to do a good bit of litigating, is I don't think I'd go down the fine road and the suspension road.
You anticipated my comment, because what good is it if you have contractors loitering in the common elements or walking around without face coverings on the property when you have elderly residents who are still there to say, well, you're going to have a fine hearing in 14 days.
Yeah.
Or send us a demand and we're going to sue you. What do you do?
Well, of course, they get the famous love letter from Jay that's going to immediately be sent to them via email, hand delivery, as many ways we can get it to them that says, this is stopping now. If we have the ability to get the people out of the property or keep them off the property, I'm willing to take the self-help measure to say, sorry, contractor, you don't get to come in. You violated the rules, you're out of here. And then lastly, if we got to go to court, there's a such thing as emergency and temporary injunction. We can do that. So there are actions to be taken. And to the extent that honey doesn't work, I've got gallons of vinegar to be pouring on people. And we can have no problem in doing it if we have to.
You know, it is important as community association lawyers to remind our clients that there is a process for invoking the prescribed remedies under the statute and under your documents, but these are extraordinary circumstances. And if you have contractors that you're allowing on the property and they are violating your rules and putting your staff and your residents at risk, you have to be swift, and the consequences have to be severe and immediate. I have clients who have said, if you violate the rule, you're shut down for 48 hours. If you violate the rule a second time, you're shut down for a week. If you violate the rule a third time, you're off our property. And while that may not follow protocol under the statute, you have to protect your staff and your residents. And you have to be able to react to these things in a way that provides protection under a truly exigent set of circumstances. Rosa, you wanted to make a point with regard to releases before we go forward.
Well, the only point I was going to make was to play a little bit of devil's advocate, because many of my clients have had releases signed. And I do agree with you and Donna's comments that you really can't condition access to the pool or even the gym with the signage of a release. However, to some extent, I think it is a good acknowledgement for the board. Listen, let's think about this. The board, our clients are volunteers. We've got folks who are doing a thankless job and they're not getting paid for it. And the management company is getting paid for it, but it is still a difficult and uncertain time when we're dealing with COVID. So the way I look at it is the release would act as not only a notification, if you will, but an acknowledgement. You're saying to the owners, look, we've done what we can. And you build it into the body of the release. Maybe the release is not even the correct term, but we've done what we can. We can ensure your safety. Listen, I wouldn't go into my condo pool right now. I wouldn't go eat at a restaurant and they're open. I'm not assuming that risk and I'm not willing to do that. So I don't think there's an inherent problem in putting that out there and telling owners, sign this and let us know that you understand that it's your risk.
I'll see your devil's advocacy and I'll raise you. So opening businesses simply means that all of us as Florida residents have the choice to make a decision to voluntarily go to an Apple store, a Best Buy store, the grocery store, the barbershop, which I need desperately. Letting people come into the building and exposing your staff and your residents to people coming into the building who may be carrying the virus is not a voluntary choice for your residents or your staff. So there's an important difference between the opening of outside businesses and the opening of your facility to contractors, visitors, what have you. Go ahead.
Ken, that's actually a completely different analysis in my opinion. I've recommended to many clients as part of their phased reopening, if people are going to be doing business, a contractor's coming in to perform a renovation inside a unit, or realtors, then I think there is usefulness in getting that contractor or realtor to sign an indemnification agreement. They have no right, no pertinent right to be doing business in your building in the midst of a pandemic. So I do think in that case, requiring that contractor or realtor to sign an indemnification agreement and lay out the guidelines by which they must follow when doing business right now at this point in time makes sense. To Rosa's point, I agree, Rosa. It is certainly a tool in your toolkit. I think boards need to understand that it's not a cure-all. They still have to be providing, if they're getting releases and they're providing that standard of due care, then I think they're probably fine. But it's not a substitute, it's not an in lieu of situation.
I agree with you 100% on that, Donna. And I think you can't say to somebody, we're not going to do the ingress and egress arrows and traffic control around the pool. We're not going to do it, even though it's required, and you're on your own. No, you have to do what's expected of you, but owners also need to know that you cannot guarantee and warranty their health.
Frankly, I think it's even more important than having the contractor sign the hold harmless agreement to have the contractor and the owner both acknowledge that if they violate our rules that are designed to protect our staff and our residents, they are going to be put off the property. Secondly, that if the virus takes a turn, an upward turn, that we reserve the right to put a stop to the work and put a stop to the access if it is necessary to respond to a change in the direction of this virus. One of the other things that is being required, and I want to direct this to you, Rosa, is if we're going to allow a contractor to come into the building to renovate your unit, can we require you to pay for a monitor to make sure that the contractor follows our safety protocols?
Well, that is a real loaded question, because that right there has been the, you know, the source of a lot of friction between owners and the associations since this whole COVID-19 thing exploded.
Well,
because
the access for contractors has been the source of friction. Most owners who want to do extensive renovations, they'll say they're willing to pay for it, but I'm saying, can a board require an owner to pay for a monitor? And can they require the owner to pay to clean up the portions of the common elements that the contractors have had to travel through?
that's what I'm referring to as well, though. And I do have clients that have required owners to do that. Now, so, you know, that begs the question, is that a legal fee to charge an owner? What I tell my clients is that the best way to resolve this, and it's not an immediate resolution, is to amend your condo documents to include these kind of charges, because not unlike what Donna's group is doing with the emergency powers, once it's in the statute, it's in the statute and it's clear. Once this is in your governing documents, it's in your governing documents and it's clear. There won't be any more questions about whether or not it can be charged. I believe it is appropriate to charge it, because were it not for the owner's actions, if you will, that charge would not have been required, such as an extra cleaning of the elevator when your contractor schlepped in a bunch of contractor materials and what have you.
The questions posed to the board now are challenging, and I think it is important to have very clearly written regulations if you're going to allow any sort of access. But I think it is more important than ever, because a lot of boards, they get the adrenaline flowing through their veins when they're writing those rules. And then when it comes time to enforce them, well, you know, I play golf with this guy, you know, I have drinks with them, you know, we go out as couples. And suddenly the appetite for enforcement doesn't reflect the appetite for drafting when the rules were being created. It is.
But Ken, do you think, just so we can put a bow around this, do you think that, and I'd like to know what the panel thinks, I've been telling my clients that it's okay to charge those extra costs to the owners. Does anyone disagree? Because right now, most associations don't have it in their rules and don't have an amendment done. So what do you guys think? I mean, are you counseling your clients that it's okay to charge?
Donna?
Yes, I agree with Rosa. I am counseling that under the current emergency powers, as well as the powers and purposes provision found in most documents. But I will tell you, Rosa, that this is, again, one of those challenges that this pandemic has revealed, that the pandemic task force is looking to clarify in the statutes for next year. So we will be putting in there, and we're treating it almost as a limited common expense, that if you want to move in, let's say, or do a construction project in the midst of a pandemic, there's risks associated with that. The board should be able to specially assess you for those costs. But right now I am agreeing with you, and I am telling my clients that I believe there's enough wiggle room in the current statute and in most of their documents, without it being specific, but there's still enough authority and power in most of these documents where I think we can make that recommendation.
Jay?
Yeah, I think you can charge it, and for my excellent, wonderful clients that I love that have come and had me rewrite their documents, I can do this other thing that's important, starts with a C, which is collect it. I think that the problem that we have a lot of times is that if you're still working with developer documents or documents that are several decades old, you may not have good collection language for those. So do I think that it's legally defensible to charge charge it? Yes. Do I have a lot of good tools to collect it? Depends who you are, depends whether you have protected yourself by having one of the people that you're staring at now rewrite your documents to make sure that you have that right. So charging it's one thing, collecting it's another, and I think it's a case-by-case situation.
David? Come on, somebody disagree. Come on, David.
I think it's probably not surprising that I'm a little bit more cautious on this issue than possibly some of my colleagues. You know, the times where I have had this issue come up, I've had the good fortune of well-written condominium documents that have, you know, given me a solid argument to say to my client, hey, I think there's a good chance that we can not only charge this, but collect it. If the condominium documents are, you know, lacking, you know, then you have to look to the statutes. And it does get you into the murky waters of what does and what do the emergency powers mean and what don't they mean. So, you know, look, as you mentioned, Ken, one of the realities is if a unit owner wants to pursue these renovations, they're so eager to get it started that they oftentimes are willing to pay a reasonable fee. So, you know, I haven't seen that threatened as a potential lawsuit. If it does end up in a lawsuit someday, it'll be an interesting analysis. But, you know, again, this goes back to some of the tried and true best practices. If you've got good condominium documents, they can come to your rescue. If your condominium documents are from 1983 and still refer to the developer and have never been substantially amended, you know, best of luck.
This is another recurrent theme or repeat theme from our last webinar, at which I believe it was Donna who mentioned the importance of learning from this crisis when you turn to your documents for an update next. Not only are you working on the statute now, but you emphasized at the last webinar the importance of your documents. Jay, I want to come back to you. You spoke of the business judgment rule, and we talked about all the factors that David and Donna and Rosa addressed with regard to how the board balances its obligation to exercise emergency powers as this pandemic evolves and as there's a move toward reopening. Part of exercising business judgment is relying on experts. Earlier, you talked about using the business judgment rule by taking a holistic view of what's going on in your building. Where do you look for expert guidance in terms of exercising reasonable business judgment as this crisis unfolds? Has it changed from what it was last time?
I mean, well, the guidance has changed. I mean, the facts have changed and the guidance has changed. So I don't know that the areas of where you're going to seek this guidance has changed. I mean, those areas are the CDC. It is the Department of Health. It is any medical professional that maybe you have in your community that can provide opinions as to what you should do. You guys got to remember with the business judgment rule, it is that you are relying on some factor to make the decision. It's essentially showing your math to the court. It's saying the reason why we came to 4 is 1 + 1 + 1 + 1 and showing what you did. And then the court just doesn't say, you know, well, we think you should have had a 2 in there and the answer is 5, right? I mean, that's the business judgment rule. So I think you should be looking at those different guidelines for the specific rules. And look, at the end of the day, I do think you need to, and this isn't just a shill for business, although maybe it is, but you need to talk to your lawyer about what are the outside guidelines. You know, we are here to keep you drawing inside the circle. And if you get advice from, say, a medical professional that wants you to do something that your legal professional says you just can't do or you shouldn't do, you need to weigh those in concert with each other and have that conversation. So, you know, there's 2 different things here. One is make sure that you are following whatever guidelines that you can find. What that takes research, that takes time. The second is to document from those either guidelines or those professional opinions what you learned and then formulating that into the policy. If you do that, you are providing yourself a paper trail that the court can go back and see that the association by its board took this very seriously and came to whatever decisions they did.
I think we can expect the courts, I certainly hope the courts will continue to allow the boards to exercise business judgment as long as they take into account all of the factors and as long as they try to get as much information from reliable sources as possible. I mean, don't get your medical advice from Facebook, please. There was, when we spoke last time, Jay, you commented on the court case in Walton County in front of federal Judge Vinson, I believe it was. There was another circuit court case in Palm Beach County where a board began to allow access for contractors to do renovations under certain conditions. And one of the owners sued to try to get the court to order the board to not allow them. And that owner did not succeed in getting an injunction because the court deferred to the board's exercise of business judgment without specifically quoting or referencing the business judgment rule. But again, the court looked at all the factors that the board was considering and the factors the owner was arguing and said, we don't think we're in a position to countermand what the board has decided for the community. Donna, you wanted to make a point?
Yeah, I just wanted to build on what Jay just said, and I apologize in advance if it's a shameless plug, but, it can be a daunting task for boards and managers to try to track down all this information. The professional advisors that you're working with can go a long way towards helping you do that. Becker early out created a COVID-19 webpage, which served as a clearinghouse and Rosa mentioned the DOH guidelines, the CDC guidelines. We also had in David's office on Southwest Florida, we had partners and associates that were tasked with compiling all of the orders throughout Florida and updating them, because as we know, it wasn't just one order, those orders continued to be revised. So it is important that boards work with professional advisors that can help kind of lighten the load in terms of reaching out and figuring out the different reliable resources upon which they can build their protocols.
Thank you. When we were together last time, and we touched on it a little bit already, we talked about the expanded uses of technology and how the pandemic has forced communities to embrace the use of technology, in this particular case, to conduct meetings. So what are your associations doing and what changes to the statute might be worth considering with regard to meetings? Let me give you a specific question. We'll go around the panel. Should board meetings offer Zoom for all open board meetings? Should Zoom be available for all members who want to attend? David?
Well, I'll tell you, I'm always in favor of transparency. I find that a lot of conflicts in community association living arise from lack of transparency. So in general,
or perceived.
Right, or perceived, right. And, from my perspective, I think it's a good best practice. Now, that being said, I'm aware of many of my clients that are not fans of Zoom in any way, shape, or form. That's putting it politically correct, that characterization. So I certainly understand in some communities there will definitely be pushback for that. And candidly, I'm not the most technologically savvy guy in the world, and I know a lot of board members out there have had some frustrations with some of the technological side of things and are worried about one more headache. But in general, it promotes transparency, and in general, I think it's a good idea.
Jay?
Yes, I mean, look, in our area, we're a lot of absentee owners. I mean, a vast majority of my clients, they live in Nashville, they live in Atlanta, they live in Baton Rouge and New Orleans, and they don't live here. So teleconferencing for board meetings has always been kind of a big thing here, and Zoom's just the next step in it. I would also say that the law kind of supports this with respect to board meetings. The Not-for-Profit Corporation Act has recognized for some time that remote access by board members is okay and that they can participate. And of course, with the community association spin on that is that owners are allowed to speak and be heard, but not actually have to be counted for quorum or anything for board meetings. So look, video technology is not for everybody. I think it's a good step forward. It's something that I would promote as being good policy, good standard operating procedure. But I think that at least for my clients, we've been doing this remote board meeting stuff for quite a while.
Donna?
Well, you know, I think the same concerns that we saw with online voting a few years back, that, you know, it was going to be confusing, it was going to be difficult, and there may be problems, has not really been borne out in practice. We've seen more and more communities embrace online voting, and I'm going to go out on a limb and say we're going to see the same thing with these Zoom virtual meetings. You know, I've conducted a number of them. I know my fellow panelists have as well. Right now, the current wording of the emergency powers in 718, 719, and 720 says that boards can cancel and reschedule meetings. It doesn't say anything about can hold meetings electronically, although we have recommended that, and I've recommended that time and again, because it's much safer. It was much safer during a pandemic to do it virtually if you couldn't space out and control social distancing, and it was a way to continue to keep your people informed, as opposed to simply saying, we're going to cancel all meetings. So I think it was a nice compromise. And I'm going to say that, you know, if my task force does its job, we're certainly going to make it clear that you can have electronic meetings.
Rosa?
I wanted to say that in terms of membership meetings, there seems to be a gap.
Meetings yet. Don't jump ahead of me, please.
Oh, okay.
That's going to be the next question. We're talking about board meetings right now.
In terms of board meetings, then yes. I mean, first of all, the statute has always allowed it, and our clients many times have had board meetings by telephone conference. So this is more useful, more state of the art. You're actually looking at people. So there's really no reason why that shouldn't be the case. I mean, honestly, I think that the best way to do this is to have someone, the host, understand the technology so they can mute and unmute and, et cetera, as necessary. Because if you have a board meeting with 5 board members and 100 people in attendance, that could be, they can step all over each other and it could get kind of, noisy. So I completely agree that it needs to be or should be included in the legislation that Donna's working on. And once again, my mantra is amend, amend, amend. This is something that would be beautiful to see in a set of bylaws.
It is, I think it's worth noting that, as Jay pointed out, the not-for-profit statute allowed this, and you can actually, the board could adopt a resolution to allow members to attend membership meetings over speakerphones. David alluded to some reticence to implementing that. And for anybody who has ever had a friend, a colleague, somebody else who uses a speakerphone and can speak for 15 minutes seemingly without stopping to breathe, we all know people like that. The boards have not embraced and did not embrace that sort of attendance because they feared somebody could just start talking on a speakerphone and you couldn't get back to the meeting. But one of the advantages of Zoom, and I'm glad you pointed it out, Rosa, is that with the Zoom feature, everybody can attend, you can see everybody, and if somebody wants to actually ask a question, there's a raise your hand feature on the app where your line can be unmuted so you can ask your question, and then you can go back. I was actually at a meeting last week where if people talked for too long, the administrator muted their line and stopped their question. How many board members out there would like to have the ability to do that? They all just raised their hands. But I want to, kidding aside, I completely agree with the notion of creating the ability to facilitate attendance and participation, because you remove a lot of question and resentment and skepticism and backbiting if you operate as transparently as possible. Now, the harder question, membership meetings. From a pure operational standpoint, in terms of standing and voting and, in terms of standing up and speaking, it's the same, but should members be able to attend membership meetings over a Zoom call? Donna, you alluded to the online voting statute, which says that if you vote online, you count toward a quorum. Why shouldn't the statute say you can attend via Zoom? And frankly, we're looking at you. We know it's you, unless you've got some really out of this world technology. Why shouldn't we be able to attend membership meetings by Zoom and count as if we're there?
Well, I think you should. And to Jay's point, I think it's going to increase membership participation in important votes. And in Rosa's market as well, and in our market. You've got a lot of, and David's too, across the board, you've got a lot of people for whom their Florida properties may be second homes, may be investment properties, and anything we can do to increase membership participation is a good thing. How many times have we heard from associations, and Rosa's mentioned it a couple times throughout this webinar, and it's so important that a lot of these issues and problems can be addressed if we could amend our documents to give the boards the authority. So when there's pushback, we say, look at article such and such, section such and such. Having, increasing membership participation by allowing members to participate electronically who otherwise would be precluded from participating can go a long way towards getting those votes that you need to get, whether it's a vote on reserve funding or it's a vote on material alterations or amendments.
Should you be able to voice vote at a membership meeting over a Zoom call?
So I believe
think about it for a second. I mean, Jay is sitting right there. If he's a member of our association, I say, Jay, do you vote in favor of this amendment or against this amendment? Why is his vote any less reliable in this format?
But before I turn it over to Jay, their technology is there. I just had this at a meeting. You can do a show of hands, or you can do a roll call voice vote. But what I would say is you need to coordinate with what you sent out. Okay, so if you have sent out limited proxies for certain membership votes, then you may want to go that route. If there's anything else that didn't come up or wasn't addressed on the limited proxy, then you may be able to do that by a voice vote. But this does require some collaboration and coordination, and I would suggest that no board does this without consulting legal counsel.
Does anybody else on the panel want to make a comment about members attending membership meetings by Zoom and voting at membership meetings through some new means using technology? Jay, I'll go to you first.
Yeah, I mean, I think that it's aspirational. I think that we would need to have legislative action. I think that right now I'm scared to advise my clients to, let's say, have a special assessment vote in that manner where the unit owners have to, or the lot owners have to approve it. I'm just not sure the law supports it right now. I'm hopeful that we are moving towards a time where we will have that. I mean, look, it seems like the legislature discovered that the internet existed in 2015 when we came up with online voting. It's like, look, we can use these tools to help participation. We should, but we need the cover from our legislators before we get the association in a bind.
I want to make a final comment on this, and then I want to go to final thoughts because we've run a few minutes over. I think it would be great if there were a way to combine, speaking of shameless plugs, Donna, if there was a way to combine our online voting software, Becker Ballot, with this sort of a function so that you could keep the online vote open through the course of the meeting. And say, Jay, if you haven't turned in a proxy or a ballot or pardon me, voted online already, cast your vote online, and then we close down the online vote. And that way we combine the benefit of both the technology to vote online with the technology to be at the meeting. So that's my aspirational thought. Final thoughts. And I'm going to go around the panel. David, you first.
Final thoughts. Just remember some of the tried and true best practices are critically important right now. When communication with your owners, let them know why you're doing what you're doing, properly notice those membership meetings, be sure to keep good minutes explaining why you're doing what you're doing. Again, transparency will go a long way, but like, for example, my community, my swimming pool is still closed. That's a problem for me because I swim 3 times a week in that sucker, but I've received communications from my community. I understand why they did what they did, and I understand that the pool is set to be opened in July. Whether or not I choose to stick my toe in remains to be seen, but at least I know what the game plan is, which is causing me not to fire off a terse email to my manager. So communication, meeting minutes, all of these things that are going to come to your aid if you get sued, focus on them.
David, as the head of the practice group and as your partner, no more triathlons for you. I remember the last one. You were out of commission for a bit. Jay?
So my final thought last session was on the concept of courage and leadership. It took courage for you community leaders to take out that machete and close things down when it wasn't popular to do it. My final thought this time has to do with another concept with leadership, and that is facts-based decision-making over emotion-based decision-making. You're going to have pressure put on you. People are not going to like what the board is going to do. You're not going to get the credit if nothing goes wrong, but that's not the point. The point of a leader is to do the homework that needs to be done and make the decisions that need to be made for the betterment of the community. That's who you are. That's the job you've signed up for. So I would encourage all my community leaders on here to do that. Do your homework, make your decision, make it based on logic, make it based on facts and not the emotions of the community.
And make it based upon the best advice you can get from experts. Rosa?
I always have a hard time finding my unmute button. There we go. What I want to stress once again is the amendments, because a lot of clients say, well, what does the legislation say? What does the statute say? You know what? The beauty of having amendments done to your governing documents is that you can add to your governance terms and conditions and provisions that you want and that you like. I'm going to give you two quick examples. We talked earlier, David did, about the DBPR stepping in with emergency orders and then rescinding them. One of the emergency, the first emergency order left out being able to borrow funds. So many of the powers were allowed, but borrowing funds in the case of an emergency was not. I submit to you that if you're an association that wants to consider borrowing funds in the face of a pandemic, don't wait for the legislature. Put that into your governing documents. Another one is having your attendance by Zoom count as having attendance at the meeting. I mean, right now, I just went through a meeting which was for a contested amendment. We did a Zoom meeting. Everyone sent in a proxy, but it would have been easy, I think, had your bylaws allowed your attendance to be, your participation at the Zoom meeting to be considered attendance for purposes of the meeting. Maybe not so much for the vote, because I'm not too comfortable with that squishy, gray area about voice voting, but at least for purposes of a quorum. So I think that all those good things can be, amended into your documents and into your bylaws specifically.
Thank you, Rosa. Donna, I'll give you the final thought.
So, final thought is that it's evident that there is an ongoing disconnect still in Tallahassee about how private residential communities operate and the challenges that volunteer boards face. Words matter. When these executive orders are drafted and when they are putting certain obligations on volunteer boards, there should be more thought given to, okay, it's great, you can open and you got to meet all these guidelines, but what's the do boards really have a practical ability to do this? What I'd like to see and what I'd like to urge everybody listening to do is reach out to your public policy makers, reach out to your senators, your representatives, socially distanced. You may want to call rather than dropping in, but certainly they need to hear from you as to what you need. And to Rosa's point, which I think is so important, and you've all given me food for thought for the task force, Rosa in particular, one of the things we may want to do is lower the amendatory threshold for communities to amend their documents to incorporate emergency powers. Again, I think this is a great opportunity to reach out to your legislators, let them hear from your board, managers, you too. A lot of times, our public policy makers are hearing from a very small group of people who are looking to make boards, kind of rein boards in. In this case, they need to be hearing from boards saying, look, we need more tools to be able to safeguard our residents in the event of a contagion. And again, this is going to be going on for months. So to one extent or another, make those calls, send those emails. You got some free time right now because there's still some things that are closed. So it's really important to do that work.
I want to offer just a few final thoughts. First of all, I want to thank everyone for their attendance. I'm extremely grateful for this really fine panel. You guys were great. To the people out there who live in the communities, the conflicting parties, the ones who want to reopen, the ones who want to stay closed, you have to communicate. You do not want to communicate through lawyers if you don't have to. All of my partners just shuddered hearing me say that. But the reality is you all owe a duty to each other. The board may owe a fiduciary duty, but those of you who want to do renovations or want to bring people into the building or want to open it up for guests or want to just completely open it up, you need to be mindful of the people who are still there and of the needs and the fears of your neighbors. So everybody needs to sort of pull together. Otherwise, this thing really turns into a fracas. I also want to say to the boards, this is still a fluid situation. It changes every week, sometimes every day. And whatever rules you adopt today, they have to be subject to being considered or reconsidered next week or the week after that or next month. I see boards coming up with reopening plans or talking about what they're going to allow or not allow at the end of October. I think you need to decide what you're going to do for the next week. And you need to be prepared to revisit based upon what happens. The numbers are changing. In some places, the rate of infection is going down. In some places it's holding steady. In some places, it's going up. Stay nimble, stay informed, ask your questions, make good decisions. And the best way to make good decisions is to get as much good advice and gather as much input as you can. With that, I wish everyone good health. I wish everyone peace as we go through all of this. And we will be talking to you again soon. Have a good afternoon.